Hi, welcome back. This session is about the Industrial Employment Standing Orders Act 1946. The absence of standing orders in industrial establishments was one of the most frequent causes of friction between the management and workers in industrial undertakings in India. Before passing of the Act, the condition of employment obtaining in industrial establishment were governed by contracts either express or implied between the employers and the employees. In many cases, these conditions were not well defined and suffered from doubt and ambiguity. With the advent of trade unionism and collective bargaining, new problems of maintaining industrial peace and production for the society were created. It was then considered the society had a vital interest in the settlement of terms of employment of industrial labor, and thus the settlement of labor problems became tripartite, and the state representing the society entered on the scene. The tripartite Indian Labour Conference discussed this problem, and it was this conference which suggested that an act of this nature must be enacted. Accordingly, in 1946, the act was enacted. The act provided for the framing of standing orders in all the industrial establishments to which this act applies. The preamble states that the act was intended to require employers in the industrial establishment to prepare standing orders. The act was passed in order to minimize the conflict between the employer and employees on account of uncertain terms and conditions of their employment. The schedule to the Industrial Employment Standing Orders Act 1946 specifies the matters to be provided in the standing orders. Such matters include 1. Classification of workmen as permanent, temporary, apprentices, probationers, badalis, etc. 2. Intimation of hours of work, holidays, pay days and wages, etc. 3. Shift working. 4. Attendance and late coming. 5. Authority which may grant leave and holidays. 6. Requirement to enter premises by certain gates and liabilities to search. 7. Closing and opening of sections. 8. Termination of employment and notice thereof. 9. Suspension and dismissal for misconduct. 10. Means of redress for workmen against unfair treatment or wrongful execution by the employer or his agents or his servants. And 12. Any other prescribed matter. In Management of Sundar Raj Delhi Light RIV Company and versus Workers Union, 1969, the Supreme Court observed that the object of the act is to require employers to specify the conditions of service in their establishment. The act protects the interest of workmen against discrimination and unfair labor practices. The other object of the act was to have a uniform standing order providing for the matters specified in the act. So this was held by Supreme Court in Management of Sundar Raj Delhi Light Company versus its Workers Union 1969. In Bagalkot Cement Company Limited versus R.K. Pathan 1963. In Bagalkot Cement Company Limited versus R.K. Pathan, that is 1963, Supreme Court held that the provisions in the Act constitute the statutory terms of employment between the industrial establishment and their employers. In Salem Erode Electricity Distribution Company Private Limited versus Employees Union 1966. Salem Erode Electricity Distribution Company Private Limited versus Employees Union 1966. In this case, the Supreme Court held that the Supreme Court emphasized the object of the Act. The object is to regulate the condition of recruitment, discharge, disciplinary action, holiday, etc. of the workers employed in the industrial undertaking. The Act has also introduced uniformity of terms and conditions of employment in respect of workmen belonging to the same category and discharging the same or similar work in an industrial establishment. In Aluminium Industries Employees Union versus Aluminium Industries Limited 1963. In Aluminium Industries Employees Union versus Aluminium Industries Limited 1963. In this case, the court held that the preamble of the Act makes it amply clear that the standing order shall deal with the condition of employment of workers in industrial establishment. These words are wide enough to include acts which may be committed even without or away from factory premises. Now, salient features of the Act. 1. A group of employers of similar industrial establishments may submit joint standing orders if necessary. 2. Penal provisions has been provided making the employers liable for failure to submit draft standing orders for certification or for contravention of any provision of the standing orders finally certified. 3. The employer of every industrial establishment to which the Act applies is required to frame draft standing orders and to submit them to the certifying officer, who is generally the Labour Commissioner, for certification. Now, 4. The appropriate government may, by a Gazette notification, exempt any establishment or class of industrial establishments from all or any of the provisions of the Act. 5. The definition of workman under this Act include supervisory and technical personnel under certain conditions. 6. The certifying officer is empowered to modify or make additions to the draft standing order so as to render them certifiable under the Act. 7. The government may by rules set out model standing orders for the purpose of this Act. The draft standing orders framed by an employer should, as far as practicable, be in conformity with the model standing orders. 8. The appropriate government may, after previous publication by notification in the official gazette, make rules to carry out the purpose of this Act. 9. The certifying officers and appellate authorities shall have all the powers of a civil court in respect of matters provided in section 19 of the Act. 10. The Act applies to every industrial establishment wherein 100 or more workmen are employed. Now, it is open to the aggrieved person to apply for modification of the standing orders even if it not agreed by the other party. It was so held in Statesman, Clerical Staff and Worksmen Union versus State of West Bengal in 2002. In Statesman, Clerical Staff and Worksmen Union versus State of Bengal 2002, it was held, it is open to an aggrieved person to apply for modification of the standing orders even if not agreed by the other party. Now, applications of the Act. The object of the standing order is to make it clear to both the parties on what terms and condition the workmen are offering to work and the employer is offering to engage them. This Act requires the employers to define the conditions of service in their establishments and to reduce them to writing and get them compulsorily certified with a view to avoid unnecessary industrial dispute. The Act applies to every industrial establishment. 1. Situated within the Indian Union except the state of Jammu and Kashmir. 2. Employing 100 or more workmen on any day of the preceding 12 months. The appropriate government may, by a Gazette notification, apply the Act to any industrial establishment employing such number of persons as specified in the notification. The number of employees fixed by the government may be less than 100. But the appropriate government must give 2-month prior notice of its intention to make any such extension of the Act. The Act does not apply to the following establishment. That is 1. Any industry to which the provisions of Chapter 7 of Bombay Industrial Relations Act 1946 apply. So, any industry to which provisions of Chapter 7 of the Bombay Industrial Relations Act 1946 apply. And second one, any industrial establishment to which the provisions of the MP Industrial Employment Standing Order Act 1961 apply. So, any industrial establishment to which the provisions of the MP Industrial Employment Standing Order SO Act 1961 apply, provided that notwithstanding anything contained in the Madhya Pradesh Industrial Employment Standing Orders Act 1961, the provisions of this Act shall apply to all the industrial establishments under the control of the central government. Now, in Avery India Limited versus Second Industrial Tribunal West Bengal, in Avery India Limited versus Second Industrial Tribunal West Bengal, it was held that the provision as to the age of retirement in the standing order of an establishment would apply to all employees irrespective of whether they entered into the service prior to or subsequent to the coming into the force of the standing order, and even though there was no such provision of retirement in the past. So that was held in Avery India Limited versus Second Industrial Tribunal, West Bengal. Now, in Management of MIS Shiva Flour Mills, Bhagalpur versus Workman, 1970. Management of MIS Shiva Flour Mills, Bhagalpur versus Workman, 1970. In this case, it was held that in the absence of any standing orders or rules, law of master and servant governs relationship between employees and employer. Now, in ML Kantarao versus Assam Jahi Mills Limited, Warangal, 1970. ML Kantarao versus Assam Jahi Mills Limited, Warangal. When the employer chooses to provide sick leave under the standing order, which in view of the preamble of the Act is really a part of the condition of service by which the employer is bound, the standing order confer on the employee as a matter of contract the right to sick leave. The employee can exercise his right and the employer cannot require him to seek the sickness benefit under the Employees State Insurance Act. Now, exemption under section 13 subclause B of certain industrial establishment. The Act does not apply to such workmen employed in any industrial establishment as are covered by the following rules and regulations. 1. The fundamental and supplementary rules. 2. The civil service classification, control and appeal rules. 3. The civil service temporary service rules. 4. The revised leave rules. 5. The civil service regulations. 6. The civilians defense classification, control and appeal services rules. 7. The Indian Railway Establishment Code, or 8. Any other rule or regulation that may be notified in this behalf by the appropriate government in the official gazette. It is clear that these rules do not apply to any industrial establishment under private management or under the management of a statutory corporation. The appropriate government may extend the Act to any classes of industrial establishment as it deems fit. Further, Section 14 of the Act authorizes the appropriate government to exempt conditionally or unconditionally any industrial establishment or class of industrial establishments from all or any of the provisions of this Act. Now towards the definitions in the Act. Industrial establishment. Industrial establishment means 1. Industrial establishment as defined in Clause 2 of Section 2 of the Payment of Wages Act 1936. So that is Section 2, Clause 2 of Payment of Wages Act 1936. Or 2. A factory as defined in Clause M of the Section 2 of the Factories Act 1948. So Section 2, Clause M of Factories Act 1948. Or third, a railway as defined in Clause 4 of Section 2 of Indian Railways Act 1890. So Section 2, Clause 4 of Indian Railways Act 1890, or the establishment of a person who, for the purpose of fulfilling a contract with the owner of any industrial establishment, employs workmen. So, industrial establishment means, and it is inclusive of 4 circumstances or 4 definitions. That is, the first one, Section 2, Clause 2 of the Payment of Wages Act 1936, and the second one is Section 2, Clause M of the Factories Act 1948. The third one is Section 2, Clause 4 of the Indian Railways Act of 1890. And the fourth scenario is the establishment of a person who, for the purpose of fulfilling a contract with the owner of any industrial establishment, employs workmen. In Karnataka Agro Industries Corporation Employees Association versus State of Karnataka 1987. Karnataka Agro Industries Corporation Employees Association versus State of Karnataka 1987. In this case, it was held that 5 workshops of Agro Industries Corporation registered under the Factories Act together employ more than 100 workmen, and hence they come under the definition of industrial establishments covered by Industrial Employment Standing Order Act. Now, in another case, that is K. Tiruvenkataswamy versus Coimbatore Municipality 1968. K. Tiruvenkataswamy versus Coimbatore Municipality 1968. It was held that Electricity Department of Municipality is an industrial establishment, and also that the Act and the Model Standing Order framed thereunder apply to a person who is an employee of that department. Now, that is with the definition of industrial establishment. The next we have standing order. Standing orders means rules relating to the following matters set out in the schedule of the Act. The Act is the Standing Order Act. So, here Industrial Employment Standing Order Act of 1946. The first one, classification of workmen, that is whether permanent, temporary, apprentice, probationer or badalis. So we are going to discuss about what are the rules that has to be mentioned in a standing orders. That is, standing orders means rules relating to the following matters set out in the schedule of the Act. So what are these matters? That is, the first one is the classification of workmen. So the workman can be either permanent or temporary or apprentice or probationer or badalis. Now the second one is manner of intimating to the workman period and hours of work, holidays, paydays and wages, etc. The third is shift working. Fourth is attendance and late coming. Now 5, conditions of procedure in applying for and the authority which may grant leave and holidays. 6, requirement to enter premises by certain gates and liability to search. 7, closing and reopening of section of industrial establishment and temporary stoppage of work and the rights and liabilities of the employer and workmen arising therefrom. 8th one, termination of employment and the notice thereof to be given by the employer and workman. 9, suspension or dismissal for misconduct and acts or omission which constitute misconduct. 10, means of redress for workmen against unfair treatment or wrongful exaction by the employer or his agent or servants. 11, any other matter which may be prescribed. So any rules relating to these matters is a standing order. For the above specified matters, an employer is allowed to prepare a standing order. The burden of proof is always on the employer to prove that the subject matter is covered in the above items. So here the burden of proof to bring a matter under standing order, the burden of proof is on the employer. Now, in New Victoria Mills versus Presiding Officer Labour Court, New Victoria Mills versus Presiding Officer Labour Court 1970. In this case, Mr. A was a sweeper employed in the Victoria Mills. Mr. A committed theft outside the mills. The management terminated the service on the ground of misconduct. So the question of law was whether it is misconduct within the meaning of the Act. The court held that all that has to be shown is that the alleged misconduct affects the competency of the employee for the particular kind of work he does. So the importance of his case is that the misconduct need not be committed inside the industrial establishment. So that was held in New Victoria Mills versus Labour Court. New Victoria Mills versus Presiding Officer Labour Court. Now, the next case law we have here is Saroja Kumar versus Chairman Orissa Electricity Board 1966. Saroja Kumar versus Chairman Orissa Electricity Board 1966. The court made a distinction between termination of employment and superannuating. The former is a positive act, that is, termination is a positive act by which one party, even against the desire of the other, can bring about the end of the employment, while the superannuation is an event which occurs to an end in an automatic process. So, the distinction between superannuation and termination of employment was clearly explained in Saroja Kumar versus Chairman, Orissa Electricity Board, 1966. Another case law, that is S.K. Ghosh versus Chairman, OSC Board, 1970. S.K. Ghosh versus Chairman, OSC Board, 1970. In this case, it was held the clause termination of employment in the item 8 of the schedule and the word superannuating cannot be equated. The former is a positive act which one party, even against the desire of other, can be brought about the end of the employment, while the latter is an event which comes more or less in a automatic process. So, in S.K. Ghosh and Chairman, OSC Board, 1970, that also explains the distinction between termination of employment and superannuation, and it was also discussed in Saroja Kumar versus Chairman, Orissa Electricity Board. So, Saroja Kumar versus Chairman, Orissa Electricity Board, then S.K. Ghosh versus Chairman, OSC Board. Both the cases explain and set out clearly what is the difference between termination of employment and superannuation. Termination of employment is a positive act and superannuation is an automatic act process. Now, in Sarayu Singh versus National Seeds Corporation, 2017, that is 2017. So, Sarayu Singh versus National Seeds Corporation, 2017, Supreme Court held that termination as was after the publication of advertisement in newspaper requiring employees to report for duty. So, he is not entitled to back wages. So, this case was regarding entitlement for back wages. That is Sarayu Singh versus National Seed Corporation, 2017. Supreme Court held that as termination was after publication of advertisement in newspaper requiring employees to report for duty, he is not entitled for back wages. Now, another case law, that is Naveen Chandra Shekhar Chand Shah versus Ahmedabad Cooperative Limited. Now, Naveen Chandra Shekhar Chand Shah. Naveen Chandra Shekhar Chand Shah versus Ahmedabad Cooperative Limited. The petitioner, who was a helper in the respondent society, was charged sheet for overweighting wheat to a customer and was dismissed from service after an inquiry. It was held that mere negligence is not misconduct. Mere lapse is not enough. It must be habitual to constitute misconduct. So, that was held in Naveen Chandra Shekhar Chand Shah versus Ahmedabad Cooperative Limited. The next definition is about wages. It is defined in the same manner as in the Industrial Dispute Act. So, Industrial Employment Standing Order Act, here wages has the same definition as that in Industrial Dispute Act. And the next definition we have here is employer. The expression employer means the owner of an industrial establishment to which this act for the time being applies. It also includes 1. In a factory, any person named under clause F of subsection 1 of section 7 of Factories Act 1948 as the manager of the factory. That is section 7 subclause 1 subclause F 7 clause 1 clause F Factories Act 1948. A person in a factory, any person named under this section 7 clause 1 clause F as the manager of the factory, that person is an employer. Then the second condition, this definition is inclusive in nature. It is said that it also include, the first one is section 7 1 clause F of Factories Act 1948, who is termed as a manager of the factory under this provision. The second one, in an industrial establishment under the control of any department of any government in India, the authority appointed by such government in this behalf, or where no authority is so appointed, the head of department. Or the third inclusion is that in any other industrial establishment, any person responsible to the owner for the supervision and control of the industrial establishment. So, With the definition of employer, the expression employer means the owner of the industrial establishment and to which the Standing Orders Act applies. Along with it, it is also inclusive to include any person termed who is brought under as a manager of a factory by the provision of the Factories Act, that is section 7 clause 1 clause F, or any person or head of department who is appointed as a head of department by any government or acts in that behalf with or without authority. Then any person who has to report to the owner of the industrial establishment as responsible for the supervision and control. So all these people come under the definition of employer. So it's not just the owner, it is also inclusive of the manager, supervisor, or person who is acting on behalf of the owner. All come under the definition of employer. Now, the next term is appropriate government. The definition of appropriate government. The central government is deemed to be the appropriate government in the respect of the following industrial establishment. 1. An establishment under the control of the central government, or 2. Railway administration, or 3. Establishment in major port, mine, or oil field. So, in these 3 establishments, the central government is the appropriate government. That is under the control of central government, or the railway administration, or major port, mine, or oil field. In all other cases, the appropriate government means the state government. Proviso added by the Amendment Act of 1982 provides that where any question arises as to whether any industrial establishment is under the control of the central government, that government may either on a reference made to it by the employer or the workman or trade union or other representative body of the workman or on its own motion, and after giving the parties an opportunity of being heard, decide the question, and such decision shall be final and binding on the parties. The next definition we are going to look into is certifying officer, that is defined under section 2 clause C. Section 2 clause C, certifying officer. The following are said to be certifying officer under this act. 1. A labor commissioner, or 2. A regional labor commissioner, or 3. Any other officer appointed by the appropriate government by notification in the official gazette to perform all or any of the function of a certifying officer under the act. The next definition we are going to look into is appellate authority, defined under section 2 clause A. Section 2 clause A, appellate authority. Appellate authority means an authority appointed by the appropriate government by notification in the official gazette to exercise the function of an appellate authority under the act in such area as may be specified in the notification. But in relation to an appeal pending before the industrial court or other authority immediately before the commencement of the Industrial Standing Orders Amendment Act of 1963, that court or authority shall be deemed to be appellate authority. Now, how a standing order is to be certified, that is discussed in section 4. How a standing order is to be certified is discussed in section 4. 1. Within 6 months from the date on which the act becomes applicable, the employer shall submit 5 copies of the draft standing order. 2. The draft standing order, or the DSO, must make provision for every matter set out in the schedule which is applicable to the industrial establishment. Now, third, in case model standing orders are available, DSO must be prepared in conformity with that model. Now, the fourth one, the draft standing order shall be accompanied by a statement giving prescribed particulars of the workmen employed in the industrial establishment. The name of the trade union to which the workmen belong must also be stated. Now, 5. According to section 4 of the Act, the certifying officer is vested with the power to certify the draft if it is in order. The certifying officer is having the power to adjudicate upon the fairness or reasonableness of the provisions of the standing order. Now, in Western India Match Company versus Workmen. In Western India Match Company versus Workmen, the Supreme Court ruled that while certifying the draft standing order or the DSO, the certifying officer is to consider the weight and special interest in the claims of the employer and demands of the workman. He can modify the draft. Now, duty is cast upon the certifying officer to insist that the standing order should be in conformity with the model standing orders unless the employer can satisfy that it is not possible or practicable for him to do so. So that was discussed in Western India Match Company versus Workman. Now the next case law we have here is Associated Cement Company Limited versus RC Vyas 1960. Associated Cement Company Limited versus RC Vyas. Now, the Supreme Court ruled in this case that the draft standing order or the DSO must be in conformity with the schedule of the Act. In this case, the certifying officer modified the standing order relating to the notice period or after discontinuance of the shift. The certifying officer increased the notice period from 14 days to 1 month to bring it in conformity with the model standing order. So that is in Associated Cement Company Limited versus RC Vyas 1960. In UP Electricity Supply Company versus TN Chatterjee. UP Electricity Supply Company versus TN Chatterjee. In this case, the Supreme Court held that a certifying officer is competent to certify only those matters which are mentioned in the schedule or in the model standing order. The same view was expressed by Supreme Court in Rohtak and Hisar District Electric Supply Company versus State of UP. Once again, the same opinion was expressed by Supreme Court in Rohtak and Hisar District Electric Supply Company versus State of UP. In this case, the Supreme Court held that the employer cannot insist upon adding a condition to the standing order which is related to a matter which is not included in the schedule. Then, in another case law, that is Mahalakshmi Mills versus Labour Court. Mahalakshmi Mills and Company versus Labour Court, Rajasthan. Labour Court, Rajasthan. The Supreme Court considered the question whether there can be different conditions of service for different employees in the same industrial establishment. The scheme and object of the Act clearly show that it was not intended by the legislature that different sets of conditions should apply to employees depending on whether a workman was employed before the standing order was certified or after. According to Supreme Court, any person aggrieved by the orders of the certifying officer may within 30 days file an appeal before the appellate authority. Then next we have deviation from model standing order. The appellate authority or the certifying officer shall see whether the standing order satisfy the condition necessary for certification. They can make necessary additions or modifications in draft standing order or the DSO submitted to them for certification so as to make the draft certifiable under the Act. When the Act provides that the standing order drafted by the employers should, as far as practicable, be in conformity with the model standing order, it simply means that the model only represents a pattern and that the draft should try to resemble it. It does not mean that the draft standing order should follow the model verbatim. The model does not have the force of a statutory rule, which has to be obeyed without altering its contents in any manner. So that is with deviation from model standing order. So it is just a pattern and you don't have to exactly follow it. It's not a statutory provision. Now, reasonableness of standing order. That is discussed in section 3. Reasonableness of standing order. Section 3 of the Industrial Employment Standing Order Act of 1946 empowers the certifying officer or the appellate authority to inquire into the impracticability to the model standing order, and section 4 of the Act authorizes them to adjudicate upon the fairness and reasonableness of the draft standing order. All these inquiries by the authorities should be in an integrated manner and thus constitute there will be no conflict between two sections. That is section 3 and section 4 of the Act. Now we have a case law here, that is Jivan Lai Limited, Bombay versus their workmen. Jivan Lai Limited, Bombay versus their workmen, 1956. In this case, it was held that where the standing order made no provision regarding age of retirement, an application by the employer for adding the standing order to provide age and ground for retirement could not be ordered, as it could not be considered to be in conformity with the model standing order. So that was held in Jivan Lai Limited, Bombay versus their workman in 1956. In Associated Cement Company Limited versus PD Vyas. Here, the certifying officer modified the draft standing order submitted by the management. In respect of the standing order relating to the notice period of discontinuance of a shift, he increased the notice period from 14 days to 1 month to bring it in conformity with the model standing order. On similar ground, the standing order relating to what amounted to misconduct in relation to strike and incitement to strike was modified to include only illegal strikes. Now the next we have posting of standing orders, that is discussed under section 9. Posting of standing order, that discussed under section 9. The text of the standing order as finally certified under this act shall be prominently posted by the employer in English and in the language understood by the majority of the workmen on a special board to be maintained for the purpose at or near the entrance through which the majority of the workmen enter the industrial establishment. A copy of such standing order shall be posted in all departments where the workmen are employed. Non-compliance with these provisions by the employer may prejudicially affect the workman, but at the same time, non-compliance by the employer should not be willful or negligent. The tribunal has to keep in view all these factors in coming to a decision. It cannot be held that mere failure to comply with section 9 of the act will deprive the standing order of their binding character. Now, duration of the standing order, that is discussed in section 10. Duration of standing order discussed in section 10. A certified standing order shall be in force for 6 months. If the modification is required, it can be done by applying again. The certified standing order is like a contract, and as such, both the employer and the workman are bound by it. Now we have a case law here, that is Shahdaranpur Light Ray Company versus Railway Workers Union. Shahdaranpur Light Ray Company versus Railway Workers Union. In this case, the standing order relating to the termination of services of a permanent workman was modified, requiring the employee to give reasons in addition to giving 1 month's notice for 1 month's pay in lieu of notice. The modification was held to be fair and reasonable. But the modification of the standing order requiring the giving of second show cause notice at the stage of imposing punishment of removal cannot be considered as fair and reasonable. So that was held in Shahdaranpur Light Ray Company versus Railway Workers Union. In another case, that is Andhra Scientific Company Employees Union versus Manager, 1970. Andhra Scientific Company Employees Union versus Manager, 1970. In this case, the company sought permission to a standing order reducing festival holidays from 17 to 10. It was held that the schedule of the act only prescribed the procedure for notifying holidays, and therefore the notification purporting to reduce the number of holidays would not be in conformity with the act. The employer and workman cannot enter into a contract overriding the statutory contract. The court further held that a certified standing order has statutory force. In another case law, that is UPE Supply Company versus TN Chatterjee. UPE Supply Company, that is UP Electric Supply Company versus TN Chatterjee. In this case, the Supreme Court considered the question whether there can be different conditions of service for different employees in the same industrial establishment. It was held that the scheme and the object of the act clearly show that it was not intended by the legislature that different sets of conditions should apply to employees, depending on whether a workman was employed before the standing order was certified or thereafter. Now, the next we have payment of subsistence allowance, that is discussed in section 10 capital A. Section 10A. Payment of subsistence allowance is discussed in section 10A. The Act provides that where any workman is suspended by the employer pending investigation or inquiry into complaints or charges of misconduct against him, the employer shall pay to such workman subsistence allowance at the following rates. Now, A, at the rate of 50% of the wage from wages which the workman was entitled to immediately preceding the date of such suspension or the first 90 days of suspension. So, the Act provides that where any workman is suspended by employer pending investigation or inquiry into complaints or charges of misconduct against him, the employer shall pay such workman subsistence allowance at the following rates. So it is only when the investigation or inquiry into complaints are pending. So the first one is at the rate of 50% of the wages which the workman was entitled to immediately preceding the date of such suspension for the first 90 days of suspension. So the first 90 days he shall get 50% of the wages, and the wages is depending on the what he was getting immediately before preceding the date of such suspension. And the second is at the rate of 75% of such wages for the remaining period of such suspension if the delay in the completion of disciplinary proceeding against such workman is not directly attributed to the conduct of such workman. That is discussed in 10A clause 1. So two conditions are prescribed here, that if a workman is being dismissed or suspended where the inquiry is pending, then for the first 90 days he shall get 50% of the wages what he was getting just before his suspension. And after 90 days, if there is delay in the proceeding, and that is not because of the conduct or any mistake of the employee, then the employee, such person, shall get 75% of the wages for the remaining period. So that is discussed in section 10A. Now, if any dispute arising regarding the subsistence allowance payable, the workman or the employer concerned may refer the dispute to the labor court having jurisdiction over the industrial establishment where the workman is employed. The labor court, after giving the parties an opportunity of being heard, decide the dispute. Such decision will be final and binding on the parties. So if the employer is aggrieved and he moves to the labor court, and the labor court hears the case on merits and then makes a decision that is final and binding on both the parties. Now, if more beneficial provisions relating to the payment of subsistence allowance are in force in state, such provision shall be applicable in that state. So if there is a specialized state legislation and a more favorable provision is there in such state legislation with respect to subsistence allowance, the favorable provision shall apply. Now the next is power of certifying officer, that is discussed under section 11. Now section 11 of the Act provides that every certifying officer shall have all the powers of a civil court for the purpose of receiving evidence, administrating oath, enforcing attendance of witnesses, and compelling the discovery and production of documents. A clerical or other mistakes can be rectified. Now, the certifying officer has the power to examine the fairness and reasonableness of the standing order. He has to see that the statutory conditions are fulfilled. In the draft standing order is not fair, he has the power to direct the employer to revise the draft. The framers of the draft standing orders have to satisfy the certifying officer that it was not practicable to conform to the model standing order. So in Associated Industries versus B.B. Singh, that is 1972, Associated Industries versus B.B. Singh, the Supreme Court observed that under section 11 of the Act, the certifying officer has all the powers of civil court for certain specified purpose, but his position cannot be strictly equated to that of a court. So he has all the powers of the court but cannot be directly equated to that of a court. Now another case law, that is NGEF Limited, by Vyapanapalli versus Industrial Tribunal 1970. NGEF Limited, Vyapanapalli versus Industrial Tribunal 1970. In this case, the appellate authority, while certifying the modified standing order, certified the various versions which it has rejected. Further, while fixing various categories of leave facilities, it failed to prescribe the procedure for applying for leave and the authority who should grant it. The employer applied under Section 11, Clause 2 for rectification of these accidental slips or omissions. But the application was dismissed by the authority because the modification could be done after the expiry of 6 months from the date of clarification. Here, it was held that the authority had wrongly overlooked the scope of the application and that he erred in considering application for modification of standing order. The appellate authority had the obligation to draw up standing orders in conformity with the orders passed in appeal placed before it. Therefore, the court held that orders suffered from material omissions in the matters certified and the application made by the employer under Section 11, Clause 2 of the Act was wholly competent. Now, next is regarding penalty. If the employer does not submit the standing orders as required by Section 3 or modifies them otherwise than in accordance with Section 10, he shall be punished with fine up to 500 rupees. In case of a continuing offence, further the fine extending to 200 rupees per day may be imposed upon the employer, and this is discussed in Section 13. So the penalty is discussed in Section 13, and the Section 13 Clause 1 says that if the standing order, if the employer does not submit the standing orders as required by Section 3 or modifies them otherwise than in accordance with Section 10, he shall be punished with a fine up to 500 rupees. And in case of continuing offence, there will be a further fine extending to 200 rupees per day, and this is discussed in Section 13 Clause 1. Now, in Section 13 Clause 2, an employer who acts in contravention of the certified standing order shall be punishable with fine extending up to 100 rupees, and for continuing offence to 200 rupees per day. That is discussed in Section 13 Clause 2. So penalty is discussed in Section 13. In Section 13(1), it discusses about non-submission of the standing order or a modification not in accordance with Section 10, and the initial fine is 500 and continuing offence will be 200 rupees per day. Now, in Clause 2 of the Section 13, discuss about an employer who acts in contravention to the certified standing order will be punished up to 100 rupees and continuing offence up to 200 rupees per day. And the next we have appeal, that is discussed in Section 6. Any employer, workman, trade union or other prescribed representative of the workman agreed by the order of the certifying officer may, within 30 days from the date on which copies of the draft standing order are sent, appeal to the appellate authority whose decision thereon shall be final. The appellate authority shall by order in writing confirm the standing orders either in the form certified by the certifying officer or after amending standing order by making such modification as it thinks fit necessary to render the standing order certifiable under this Act. The appellate authority shall within 7 days of its orders send copies of the draft standing order to certifying officer, employer, trade union or other prescribed representative of the workman. In case of the appellate authority makes any modification in the draft standing order, it shall send a copy of the amended standing order along with this order. But no such copy needs to be sent by him, that is the appellate authority, if no modification has been made by the certifying officer in the draft standing order. Now, we have there's a question that comes up here, that whether two sets of standing orders in the same establishment for the same category of employees would be permissible. So with respect to this, we have a case law, that is Salem Erode Electricity Distribution Company versus the Workman 1966. Salem Erode Electricity Distribution Company versus the Workman 1966. The above question was raised before the Supreme Court. The company introduced a new rule by which workers joining the company after 1/10/1969 would be entitled to less leave than those who were already in employment. So there was two standing orders for the same set of people. To regularize this new rule, the company applied to the company officer to amend the standing order. The labor union objected this. The court held that the proposed change were unfair and unreasonable. The matter was taken before the Supreme Court. The Supreme Court held that it appears that two sets of standing orders cannot be made for an establishment under the Act. Two sets of standing order will create confusion and discontent among the workers. So that was held in Salem Erode Electricity Distribution Company versus the Workman 1966. Now, the overall impact of the Act. On the analysis of the provisions of the Industrial Employment Standing Order Act 1946, it is clear that the interests of the working community have been properly safeguarded. The purpose of the Act is to require the employees to lay down service conditions in clear terms so that a uniformity can be achieved. The schedule to the Act contains matters on which the terms and conditions must be clear. The trade unions are consulted on the point of standing orders, and after giving an opportunity to the parties, the standing orders are finally enforced. The standing orders must be published or pasted at the entrance of the industrial establishment. The ultimate success of the Act lies on the mutual cooperation of the workmen and employers for due compliance with the provisions of the Act. So that is with the end of this session. Thank you for your support. Like, comment and subscribe, and don't forget to click that bell icon so that you get an update when I upload my next video or a podcast. Thank you.